Allora, l'ultima relazione è...
And now our last presentation. We're going to talk about the European Succession Certificate. Well, actually, there will be a brief introduction about its characteristics, but then we'll try to go through some cases, a sort of a case history, hopefully enabling us to respond to those cases that have been particularly doubtful. So we're going to see how to check whether this certificate may or may not include some specific parts, and to what extent such a certificate may actually be released or not, when that can be the case. And as other speakers have already said, this is a document that accounts for a very important novelty as provided for by the 1150 regulation, which comes out of debate within the notary group, since actually the first wording of the regulation, the draft wording, was precisely due to a group of notaries who introduced it to the European institutions who somehow changed it. But I mean, in substantial terms, it was the notaries who drafted the document, which proves that one can achieve important goals by working in cooperation. So a succession certificate may be problematic because it may not be so easy to prove the actual truth of a legatee and also of an administrator of some property. In some states, such as Germany or Austria, there's a specific certificate of inheritance. So the heirs are clearly identified, and this document may, of course, be denied by a will that may come further to that date, but at least it is a document that somehow makes the circulation of property easier. In other states, such as Italy, this is not the case unless in some places. Otherwise, a private deed is, must come into play, which is also the case of France, by the way. In other countries, in the UK, for example, although it is no longer an EU member state, but it's a common law state, where only further to a certain number of, actions, as our friend Mr. Pisani may tell us, further to this mechanism, the residual net income will go to the heirs, or to the beneficiaries, in other words. Now, of course, this may entail some problems because suppose a person has a flat in Italy and, a small house in Malta or France. For him or her to demonstrate that was actually his or her property, well, his or her heirs may have, may find it difficult to actually certificate that, because these are three countries in which such a certificate simply does not exist. So in that case, an additional set of documents might be needed. So thanks to this European certificate, we try not to get rid of all the other documents, but to have, one that may always apply. We still want to use, the private deed or similar documents, but the European Succession Certificate may well apply. It is released in one member state, possibly to be used in another member state, but its scope may well be extended to all EU member states. rights. So if there's someone who has inherited property from someone whose latest residence was in Italy, but maybe he also had properties in France or Malta, well, in that case, the Italian notary might be the one to produce the European certificate to be given to the legatee, whereby the latter may be considered as the legitimate heir without any possibilities of a challenge. So it's a document that may be issued to, any authorities. In Italy, notaries are always, afraid of using this certificate, but it's much easier than we may think, And in any case, when we issue this document, we do exactly the same as we do when we sell a succession property. If someone wants to sell a property inherited by the father, we check, of course. So we check whether there's a will, whether there's a succession statement. We write down the statement of inheritance that may have been, produced. Of course, if we may have to simply use the European certificate without asking, third parties to come into play to testify that that is actually a property regularly inherited by our client. I mean, we basically exercise the same kind of responsibility as we do otherwise, but it's only simpler. Now, this European succession certificate, based on what envisaged by regulation number 650, may be considered for what it is and for what it is not. So in the regulation, we read about decisions, about, authentic instruments. Well, this is not an authentic instrument. So the European succession certificate is not an authentic instrument in the way we understand it within the framework of Italian or Maltese notaries, for example. It's not an authentic instrument as under what envisaged by the European Court of Justice. In French, it's an acte authentique. So we know that the European law acknowledges notaries, of course, in a way. Anyway, it is not a judicial decision as defined in regulation number 650. So it is basically an act that is typical of the European law. We might compare it to a voluntary jurisdiction provision because it comes from a procedure covered by regulation 650, since it may undergo changes, as it is the case of such provisions, since there's a third-party protection mechanism. So this might make things easier for us Italian notaries when it comes to the biennial checks that we must undergo. This is something that comes from an EU regulation that, because of that, does not fall within under the category of those documents that are to be checked every 2 years. And to confirm this, we might say that the European succession certificate does not have to have a specific number in the notary's file. This has been suggested by the notaries conference because the regulation says that such a certificate should be numbered and properly kept. But the conference said we already have a repertoire for that purpose, precisely in order to avoid what might happen in the case of the notary's death. For example, the contents of the certificate might get lost, hence the relevance of such conservation approach. But, this document may not fall under this category, may not be the object of these fears, because, whenever a notary takes over the previous one, all documents shall, be received by the new notary. That is what happens in Spain, for example. Not exactly the case in Italy. Having said that, maybe a separate registry might include all these certificates if they so wish. Anyway, no biennial check does not mean, freedom for all, but actually it means that it very much depends upon what envisaged by the law. Italian notaries have a code of ethics whereby disciplinary provision might derive from some wrongdoing. But I don't think we should be worried about that. There is no issue of annulment or validity. The only actual obligation derives from the use of the certificate template as in Regulation 1329 of 2014. Now, of course, one can apply for it in a free way, but the certificate must be drafted based on the relevant template, and it is issued at the end of a proceeding. So there will be an application form issued by, for example, a legatee, the notary based on that application, and further to other initiatives such as the need to listen to, a dead person's children possibly having been ruled out of the person's will, may move forward. Actually, one might wish to listen to such excluded children to decide whether the whole proceeding must be stopped or whether there are no effects on the actual release of the succession document, at least for what pertains to the part to be certified by the document itself. So the document is not supposed, to include all the property issues. For example, a current account in Germany must be closed down. It is held by a German citizen having his habitual residence in Italy, for example. So there may be some references to that particular current account. So I don't need to have the whole list of the property held by the dead person for that. Another remark is the following: the European succession certificate, precisely because it's not an actual notary's authentic instrument. So precisely because of that, this document shall not fall under the category of the rules regarding languages as envisaged by national laws, because this is a document that is drafted, as I said, on a multilingual template. So there's a template in all the EU languages, official languages. So a copy may be issued in a different language from, say, the Italian language, or else one may use a template being drafted in another language and therefore produce two certificates, but in two different languages, in perfect coordination with what envisaged by the Italian law. In other words, this must go hand in hand with another remark, namely that if for fiscal reasons the certificate may or may not have to be registered. Indeed, in Italy, based on recent paper, well, in Italy, there's no obligation of such registration. So it is a document that does not have to be registered. Indeed, in the Italian decree which deals with the fiscal property issues. Well, I'm saying this, of course, mainly for the sake of our foreign colleagues. So this presidential decree says which documents must be registered, and our, European document is not among them. Actually, we also know through the notaries conference later, notaries conference document, that the Italian Income and Revenue Agency has stated something different, that registration is mandatory. But we believe this is simply wrong, because the prerequisite is wrong, because the European succession certificate is not an authentic instrument. So from what I've said earlier, you may gather this, but also from the fact that authentic instruments must have some specific characteristics. Therefore, of course, notaries release them, but not in all member states. Sometimes it's fiscal agencies that do so, which would not be the case if the document were an authentic instrument. So there's a basic, mistake underlying the Italian Income Agency's approach. So this is a document that does not have to be registered, does not have to undergo the notary's check. Well, therefore, it can also be issued in a foreign language as of the beginning. Now, moving on with our case history, as for the usability of the certificate, let me wonder about the possible annexes to be attached to this document. Can that be the case? Can this be the case only for some property? Can I annex some documents, for example? So the answer is yes, but with a grain of salt, because the aim of the certificate is to be self-standing. So if you attach unnecessary documents, would make it null. Let me give you a tangible example. Suppose there's a will succession. Well, there's no need for me to attach the proceedings of the will sharing to the certificate. But if I am to describe an immovable, well then maybe I can do so. I may easily attach that annex. By the way, this is confirmed, indirectly confirmed by what we read in the regulations. In Regulation 1329 of 2014, we read, for example, that in the case of registered immovables, well, in order to identify the property based on the member state's law might include the attachment of some annexes. So it is the very European lawmaker who actually envisages that case. And I have also often said that this is a document to be released to legatees or administrators. And again, if there are, people who are not heirs, well, they are not supposed to apply for that document. However, since there are some administration powers that a person called to inheritance, so to speak, as we say in Italy, well, in that case, that document might be applied for, because it's a document that they might need for the sake of inheritance. May I use this certificate without identifying any property? Well, the answer was no, at least at first, because notaries believed that this is a document through which one may demonstrate the international nature of the relevant succession. Therefore, the prerequisites for the issuing of such a document. Actually, when it comes to this European certificate, well, we have often said that it may be perfectly legitimate to release it even for a national succession regime. But I mean, without prejudice to that, the succession regulation shall apply to international succession schemes. So suppose we have an Italian citizen who has died in Italy, but who used to have a current account in a Maltese bank. Well, I have recently come across a similar case. Well, it was about an Italian citizen with a common residence, with a habitual residence in Italy, but then she died in Germany, where she had recently gone, and her mother had decided she was not to be her heiress. So in Italy, this simply entails that the person shall not be an heir until the time when he or she is reconsidered as such. But that is not the case of the German law. And actually, after going deep into that with a German interlocutor, we realized that there is a way whereby to allow my client to become the actual heiress. What about the property to be included in this inheritance succession? Well, the law said that for that to actually be the case, the property should be properly identified. But there were some, there was an international nature of the inheritance issue that was considered, hence the relevance of issuing the European succession certificate. To conclude with a final example, with a final case, well, so maybe this certificate can be issued when someone who was not supposed to be an heir is considered as an heir at a later stage. So someone dies, this someone may have excluded one of his or her children from his or her will, but then there's a reintegration of this possible heir or heiress, in which case can a European succession certificate be issued to this person, so that testifies to the fact that everything happened not as under the will, but as under the applicable law? Well, the answer that the notary's conference gave is yes, insofar as the notion of succession as defined in the regulation envisages that it shall apply to, all purchase modes. So the so-called reintegration approach, which has nothing to do with the transaction, but it has to do with what, defined by a reintegration mechanism, sic et simpliciter. Well, then that is a part of the reasons whereby this can be included in the European certificate. If such a reintegration agreement is not, a simple one, but rather a transaction with, mutual concessions, then this would not be covered by the scope of the European certificate. Anyway, when that is not the case, what happens? Well, nothing without prejudice, of course, to the code of ethics, because after all, it's a useless act, simply enough. A document that could simply not be used for any purposes, including the third party's protection as envisaged by the regulation. Having said that, though, the succession certificate aims at being mutually acknowledged and recognized in all EU member states. So if I issue this certificate in Switzerland, for example, well, of course, that is not supposed to be the case, but I will not incur in any sanctions. Of course, the third party's protection will be different. So once again, the scopes are definitely extended. What I have said, you will find in the documents that I mentioned before. It includes some of the typical wordings that we are familiar with, but that are supposed to be implemented with, in connection with many, many tangible cases. And now an hour for our lunch break. Thank you.